Welcome to Abuja for a live broadcast of the judgment of the presidential election petition tribunal here at the Court of Appeal. There is a high presence of security operatives within and outside the court. And as you can see, the court is packed full with lawyers, journalists, government officials, ministers. It appears everybody is in court today. Now, the Presidential Election Petition Tribunal is about to deliver a landmark judgment in the petition of the PDP candidate, presidential candidate, Mr. Atiku Abubakar, challenging the declaration of President Muhammadu Buhari as winner of the February 23rd presidential election. Mr. Abubakar and the PDP had on March 18 dragged INEC, President Buhari and the APC before the Justice Mohammed Garba-led tribunal, praying for nullification of President Buhari's election on several grounds, ranging from his qualification to stand for the election, election malpractices, and alteration of election results. Now, in the course of the hearings, both sides tendered several documents and called witnesses. Mr. Atiku Abubakar, during the hearing, called 62 witnesses and tendered video clips before the tribunal, while President Buhari called 7 witnesses to prove that he genuinely won the election. The petitioners had, at the last leg of the hearing of the petition, alleged that President Buhari used fundamental falsehood to secure clearance from INEC to participate in the poll. Now, also in the final address presented on his behalf by the lead counsel, Dr. Levi Uzoku, Mr. Abubakar faulted the claim of INEC that he has no central server, and he asked the tribunal to uphold the petition and nullify the participation of President Buhari in the election on the grounds that he was not qualified to have stood for the election, in addition to malpractices that prompted his declaration as winner of the election. However, INEC, represented by Yunus Usman San, SAN, urged the tribunal to dismiss the petition with substantial cost because it conducted the election in total compliance with the Constitution and the Electoral Act, and also argued that INEC did not transmit election results electronically because doing so is prohibited by the law. Now, before we go, let's not forget that whichever side is not satisfied with the judgment can still take the matter to the Supreme Court within 14 days from today. So we are here on ground to bring you more details of the judgment. Please stay with us.
Yes. My Lord, with profound respect to my Lord, my name is Professor Taiwo Oshipiton. I announce appearance for the second respondents with my brothers of the Inaba. Yes. Osaro Egobiamen, Ken Moser, Dayo Akinlaja, Nanso Ekanem, Chief Olushola Oke, and the last but not the least, Akin Yoshibaju. My Lord, today being the judgment day, may I plead that we depart from the rule by also announcing some of our colleagues who are here and whose names have been ticked. I'd like to start with number 16, Aino O Salami. Next is Ogbenero Ide, Mrs. Boma Alabi, Dapo Akin Oshun, that's number 21. Number 24 is Edwin Anikwe. We also have with us number 27, Adeshino Agbede. Number 29, Jide Adejano.
Prof.
Sir.
Like the first respondent.
Oh.
Do you have to really read out all the names that are here?
I thought I pleaded for...
You have more than 60 of them.
No, man, not all of them, sir. Not all of them.
But you have mentioned some.
Yes, sir, my Lord. My Lord, may I stop with them with Adeshino Agbede?
All right. All of them are in court?
Yes, my Lord, sir.
All right.
My Lord, we're very grateful, sir.
Yes, Prince Fagbemi.
Very much obliged, my lords. Most humbly, L.O. Fagbemi, with my learned friends of the inner bar, that is, Chief Charles Edusonwan, Chief Adeniyi Akintola, Chief Bembela Anachebe,
Yes.
Chief Oladipo Okpesheyi,
Yes.
Malam YC Mekel, Malam Ibrahim Bawa,
Yes.
Dr. Chief Muiz Banire, and Malam Nasser A. Dangiri.
All right.
We have our learned friends. My lord, it's a full court and a long list. From number 13, that is to say, Nicholas Akintola Ladapo. I'll just crave your indulgence that after Akintola Deji, I made an omission and I apologize. We have Ibrahim Shafi.
After number what?
My lords, after number Akintola Deji, just shortly, before Tunde Ogala, number 14, he should come as number 15. Otherwise, my lords, everybody is present and available.
All right.
I'm very much obliged. We are appearing for the third respondent. I'm sorry, I know I'm not appearing for the second respondent, but specifically when we received hearing notice yesterday, Chief Wale Alanipekun, I got in touch with him. He's in faraway Europe, and he said I should specially convey his apology that he didn't know that the matter will be coming up today, and it's a bit difficult for him to make it. Thank you, my lords.
So let's just give you a bit of a timeline of the tribunal. Now, on the 18th of March, that was when the PDP candidate, 18th of March this year, PDP's presidential candidate Atiku Abubakar filed his petition. On May 8th, the tribunal commenced the inaugural sitting, chaired by the president of the appeal court, Justice Zainab Bukachua. The tribunal was delayed for another 3 weeks following the withdrawal of Justice Bukachua as chairman of the tribunal. However, on the 10th of June 2019, the pre-trial started and ended on July 3rd under the chairmanship of Justice Mohammed Garba, who took over from Justice Bukachua. The main petition was heard between July 4th and August 1st, after which parties adopted their final written addresses on August 21st, when the tribunal reserved judgment. Now, by the time the judgment is delivered today, the tribunal would have used 177 days of the 180 days stipulated by Section 285 of the fourth alteration of the 1999 Constitution. Also, to remind our viewers that whoever is not satisfied with whichever side is not satisfied with the verdict still can go to the Supreme Court, and judgment has to be given in the next 14 days. The parties, what is happening as the parties have just finished taking appearances, after which the chairman of the tribunal will deliver the ruling.
Gentlemen, you remember that on the 21st of August, when the parties adopted their final addresses in respect of this petition, the court indicated that judgment would be delivered on a date to be sent to the learned senior and other counsel for the parties. Now that day is today, and here you are. You also recall that during the pre-hearing session, certain applications were taken, which were argued and ruling reserved to be delivered at the final judgment stage, which is today. in line with both the Constitution as well as the provisions of the first schedule to the Electoral Act. We shall, before delivering the final judgment, deliver rulings in respect of the said applications. I will start with the first respondent's motion, which was filed on the 5th of May, 2019. And by the said, this is the leading ruling in respect of that motion. By the said motion filed on the 5th of May, 2019, the first respondent prays for, and I quote, an order of this Honorable Court, striking out the petition dated 18th of March 2019, the petitioners having failed to join the vice presidential candidate of the All Progressive Congress, Professor Yemi Osinbajo, SAN, GCON, a co-winner of the 2019 presidential election, who is a necessary party in this petition, end of quote. There are 4 grounds upon which this prayer is predicated, and I set them out in the ruling. The application was supported by a 5-paragraph affidavit and a written address. As is to be expected, the petitioners opposed this application by filing a counter affidavit of 15 paragraphs, attached to which is a written address opposing the grant of this application. The said processes were duly adopted by the learned senior counsel for the parties on the 11th of June, 2019. And the thrust of the senior learned counsel's argument on behalf of the first respondent are that 1, that the Vice President, Professor Yemi Osinbajo, SAN, GCON, is an indispensable party in this petition, and that his right to fair hearing will be breached if the petition should be determined in his absence, thus violating the provisions of Section 36 of the 1999 Constitution as amended. 2, that a combined reading of Section 133 and 137(2) of the Electoral Act makes the Vice President an indispensable party and not merely a desirable party. 3, that if it is found that Section 137(2) of the Electoral Act, which talk of a person, will mean singular, then Learned Silk urged the court to declare it void to the extent of its inconsistency with the Constitution. And 4, that failure to join the Vice President robs this court of jurisdiction to adjudicate on the petition, which, and he relied for these reasons on so many cases which are set out, including Opolubo and Ise. Citations of all are set out in the application, and he urged us to grant the application. And after a reading of consideration of all the submissions by learned senior counsel in support of the application, I go on to now deal with the merits of the issue conversed in this petition. It is imperative that in election petition, which is sui generis and governed strictly by the Constitution of the Federal Republic of Nigeria and the Electoral Act, that parties comply with the provisions set out therefore. Non-compliance with the said law in the commencement or institution of an election petition is not a mere technical rule or irregularity, but it goes to the jurisdiction of the court and robs the court of the jurisdiction because it goes to the root of the petition. I refer to the case of Buhari and Yusuf Diku citation of which is set out in the ruling. So election is neither seen as a civil proceeding in the ordinary sense, nor, of course, a criminal proceeding. It can be regarded as a proceeding sui generis. It is imperative that in the present position that the procedure laid down in the Act be strictly complied with, except to the extent that it is relaxed or waived under paragraph 49(1) of the first schedule to the Act. Section 131(2) of the Act requires that the person elected or returned be joined as a party. Section 133, which I earlier reproduced, provides in subsection 1 for persons who may present an election petition. Now, the vocal contention of the first respondent is that Professor Yemi Osinbajo, SA and GCON, as the vice presidential candidate, was a co-winner with the second respondent, whose right to fair hearing will be contravened in violation of Section 36 of the Constitution of Nigeria 1999 as amended, and that the vice presidential candidate is a necessary party to this petition. One may then ask, who is the necessary party within the context of the Constitution and the law governing presidential petition? In this case, in this vein, recourse must be had to Section 239(1)(a) of the Constitution of the Federal Republic of Nigeria aforesaid, which provides, and I quote, "Subject to the provisions of the Constitution, the Court of Appeal shall, to the exclusion of all other courts of law in Nigeria, have original jurisdiction to hear and determine any question as to whether, A, any person has been validly elected to the office of the President or Vice President under this Constitution," end of quote. Then Section 137 of the Electoral Act as amended provides as follows, and I quote again. 1, an election may be presented by one or more of the following persons. A, a candidate in an election. B, a political party which participated in the election. Subsection 2, a person whose election is complained of in this Act refers to as the respondent. And 3, if the petitioner complains of the conduct of an electoral officer, a presiding officer, a returning officer, it shall not be necessary to join such officer or officers or persons, notwithstanding the nature of the complaint, and the Commission shall, in the instance, be made a respondent and deemed to be defending the petition for itself and on behalf of its officers or such other persons. The above provisions of the Constitution and the Electoral Act have been judicially considered and applied in several cases, among which is Buhari and INEC, citation of which is set out. There's also Faleke and INEC, citation of also which is set out. Yaya Bello, ADC and Yaya Bello, citation of also of which is set out. Now, a count reading of Section 239(1)(a) of the Constitution of the Federal Republic of Nigeria shows that Professor Yemi Osinbajo, SA and GCON, is an interested party in an election challenging the return of the second respondent by INEC in the presidential election which held on the 23rd of February 2019. However, since the second respondent who nominated him as his running mate is a statutory respondent to the petition, and the third respondent which sponsored the second respondent and the vice presidential candidate are parties before this court as second and third respondent, the non-joinder of the vice presidential candidate not render the petition as constituted with regard to parties incompetent. The second and third respondents are his principals. The petition can conveniently, efficiently, competently be adjudicated upon by this court in the absence of the vice presidential candidate. We refer to the case of Kalu and Uzo, a decision of the Court of Appeal, a decision of the Supreme Court in 2004, where Adeke JSC said, as I mentioned earlier, on adequate provision must surely be made for major steps in the Constitution and the Electoral Act 2002 itself. Section 187(1) of the Constitution of the 1999 Constitution provides as follows. In an election to which the foregoing provisions of this part of this chapter relate, a candidate for the office of a governor shall not be deemed to have been duly validly nominated for such office unless he nominates another candidate as his associate for his running for the office of governor, who is to occupy the office of deputy governor. And that candidate shall be deemed to have been duly elected to the office of deputy governor if the candidate who nominated him is duly elected as governor in accordance with the said provisions. From the words above, no one is left in doubt that the actual candidate at the election is the governorship candidate who, in fulfillment of the Constitution, nominates a deputy governor. Another further is whether the deputy governor falls within the definition of the word candidate as envisaged by section 133(1)(a). There is a difference between the actual candidate who contested an election as governor and the other candidate whom the Constitution places in the shadow as an appendage. As is described in the cited cases, both governor and deputy governor stand and fall together. PDP and another, and INEC, 1999, 11 NWLR, Part 626, page 200 at 249. A deputy governor is envisaged as an interested party in the circumstances of this case, and not a necessary party. Necessary parties to an election are those covered by section 133(1) and 133(2) of the Electoral Act. A necessary party is defined as one whose participation in the proceeding is indispensable, whereas an indispensable party is one without whose presence no adequate judgment can be entered determining the rights of the parties before a court. It is a person who has an interest in the controversy that the court cannot render a final decree without affecting their interests. It is a person who must be joined because non-joinder prejudices his rights and those of the parties already joined, such that the action cannot be continued without him. In this appeal, the deputy governor to the appellant and the first respondent are surely not indispensable parties. Buhari and Yusuf, 2003, 14 NWLR, Part 841, page 446. Abubakar and INEC, 2004, 1 NWNR, Part 5854, at page 207. Uzodima and Udenwa, 2001, 1 Nigeria Weekly Law Report, Part 854, at page 303. Buhari and Obasanjo, 2003, 17 NWLR, Part 850, at page 423. It is the conclusion in this judgment that running mates for a governorship election is not a necessary party in an election by virtue of section 178 of the 1999 Constitution. He is an appendage to the candidate in the race for the governorship election, and he is bound by whatever decision the electorate or at the election tribunal decides. He rises and falls with the candidate. End of quotation. This position is true in the case of the vice president, who was nominated by the presidential candidate to contest the presidential election. Similarly, this position was restated by Karibu White, JSC, in yet another case, Ayorinde and Oni, citation of which is cited. His Lordship has said, the situation in the Eastern Appeal is different from the cases relied in the submission by learned counsel to the appellant, where a necessary party to an action for one reason or the other was not joined. The non-joinder will not render the judgment a nullity. It is a correct proposition of the law that where an action is properly constituted with a plaintiff with legal capacity to bring the action, a defendant with the legal capacity to defend, and a claim with cause of action against the defendant, and the action has satisfied all preconditions for instituting the action, the fact that a necessary party to the action has not been joined is not fatal to the action and will not render the action a nullity. Where the nature of C. Oladeinde and Oduole, 1962, Western Nigeria Law Report, 41. Where the nature of the evidence before the court is such that the case of the parties before it can be determined in the absence of those not joined, it can proceed to do so. It is only in those cases where it will not be right and the court cannot properly determine the issues before it, in the absence of the parties whose participation in the proceedings is essential for the proper, effectual, and complete determination of the issues before it, will it be necessary to insist on the joinder of such necessary parties. End of quote. I also set out some other cases on the same position of the law. I also made reference to the ruling of this court delivered on the 22nd of August 2019 in the petition number CA/A/PEPC/29, 2009, Chief Ambrose Albert Owuru and the President Muhammadu Buhari and two others in the applicant's motion number of 9th of May 2019, seeking the same relief. In the premises of the binding Nigerian authorities decided on their peculiar In the premises of these binding Nigerian decisions, the Kenyan foreign authority decided on the peculiar facts and the Constitution cited by the first respondent applicant are not opposite on the position of the law in Nigeria, and so they are not applicable. In the result, the prayer of the first respondent seeking to strike out this petition for non-joinder of the vice presidential candidate of the second and third respondent as a party to this petition is not well grounded in law. It lacks merit. It is refused and hereby dismissed accordingly. Malana brother to my immediate right will pronounce his own decision in respect of this motion.
I agree with the ruling just delivered.
Malana brother to my immediate left would also say his decision in respect of this motion.
I also agree.
Malana brother to my extreme right will now say his own decision in respect of this motion.
I also agree.
Malana brother to my extreme left would also say his decision in respect of this motion.
I agree.
Now, the first preliminary objection being heard is the one filed by INEC, asking the tribunal to dismiss the petition of the PDP and Mr. Atiku Abubakar for not joining the vice president who participated in the election as a necessary party. This objection to be decided was that which was filed by INEC. The preliminary objection was filed asking the court to dismiss the petition for failure to join the vice president who is a party to the election on 4 grounds, as he is an indispensable party in the election. The preliminary objection said failure to join the vice president robbed the court of the powers to hear the petition. As such, it should be dismissed. The tribunal has dismissed this preliminary objection filed by INEC, seeking a dismissal of the petition of the PDP and its presidential candidate Alhaji Atiku Abubakar for failure to join the vice president as a party in the suit, having participated in the election that is subject of the appeal.
I will now deal with the second motion filed by the first respondent. And this is the leading ruling. The next motion filed by the first respondent was the motion filed on the 25th of April 2019. And it was brought pursuant to paragraph 4 sub 5, 12 sub 5, and 53 sub 5 of the first schedule to the Electoral Act, and under sections 2 and 24 of the Legal Practitioners Act, cap L11, Laws of the Federation of Nigeria 2004. The first respondent is praying for the following reliefs. 1, an order granting leave to the first respondent / applicant to move and argue this application during pre-hearing session, which has been overtaken by the argument of the application. 2, an order striking out the petitioner's list of documents to be relied upon in this petition, which was filed on the 18th of March 2018, and which appears at pages 140 to 145 of the petition filed on the 18th of March 2019 for being incompetent. 3. An order striking out the petitioner's list of petitioner's witnesses, which was filed on the 18th of March 2019, and which appears at pages 146 to 157 of the petition filed on the 18th of March 2019 for being incompetent. 4. An order striking out grounds D and E of the petition, which appear at page 7 of the petition for being incompetent, as same fall under pre-election matters. And 5. An order striking out the underlisted paragraphs which allege improper accreditation, non-authentication of results, overvoting, inflation and deflation of votes, and wrong entries in Form EC8A for being imprecise, nebulous, and vague, having failed to identify the polling units where the alleged infractions took place, namely, and they set out the states. 6. An order striking out the underlisted paragraphs which allege breaches, non-compliance, and corrupt practices on a state-by-state basis, same being imprecise, nebulous, and failed to state the particulars of the polling units where the alleged infractions took place. Namely, there are so many paragraphs, and they are all listed out. An order striking out paragraphs 227, 231, 232, 233, 234, 236, and so many others of the petition, which allege arrest, harassment, and intimidation by the Nigerian police and the Nigerian army when the agencies were not joined as parties to the petition. And lastly, an order striking out the underlisted paragraphs of the petition, which allege violent acts and intimidation against named individuals who were not joined as parties to the petition. The paragraphs in question are paragraph 277, 319, 326, 334, 336, 338, 352, 368, 369, 370, 371, and 372, as well as 383. The application is predicated on several grounds, which I have set out in the ruling. There are so many of them. The application is supported by a 5-paragraph affidavit and a written address. The petitioners opposed the application and filed a counter affidavit of 10 paragraphs, along to which is attached an exhibit. The exhibit is an instrument conferring upon one Levi I. Uzoku the rank of Senior Advocate of Nigeria by the Legal Practitioners Privileges Committee on the 20th of September, 1999. The learned Senior Counsel for the petitioner also supported the counter affidavit with the written address dated the 30th of April but filed on the 1st of May 2019. The learned Senior Counsel for the first respondent also filed a reply. In the address, the learned Senior Counsel for the first respondent nominated a single issue for determination in this application, and it is whether the prayers of the applicant in the present application should be granted, considering the circumstances and contents of this petition, compared with the mandatory provisions of the Electoral Act 2010 as amended, the Legal Practitioners Act, and the Constitution of the Federal Republic of Nigeria 1999 as amended. The learned Senior Counsel argued this issue, and after a consideration of the arguments, the arguments by learned Senior Counsel for the parties, I went on to consider the merit or otherwise of this application. And I said a defendant or respondent to an action or a suit who conceives that a court or tribunal is robbed or devoid of jurisdiction to deal with the relief sought in a suit is entitled to move the court to terminate the action or suit in limine. And for this, I refer to the case of Arueze and Nwokori, citation of which is cited. As could be seen from the reliefs on the motion under consideration, the first respondent is challenging the jurisdiction of this court to entertain the petition and the competence of the petition, which also by extension questions the jurisdiction of this court. The law is now firmly settled that it is never too early or too late in the course of judicial proceedings to raise the issue of a court's jurisdiction to entertain and adjudicate over a case brought before it. On this, I made reference to a number of cases including State and Onagura, and Efiodomi and Okonko, citations of which are set out. It is also the law that due to its very crucial intrinsic and extrinsic nature to judicial proceedings, the issue of jurisdiction can be raised, in the words of the Apex Court, in the case of military administrator of Ondo State and Kolawole, decided in 2008, citation of which is set out, said, can be raised, and I quote, by whatever name and under any shade can be raised at any stage. It can be raised viva voce, or the court can raise it suo motu, end of quote. See also Nuhu and Ogele, citation of which is set out. There must be jurisdiction in a court or tribunal approached by a litigant for adjudication over a cause or matter brought before it. And where the court lacks the jurisdiction to sit over a matter, such matter will be struck out without much ado. The court is, however, seized of the jurisdiction to decide whether or not it is vested with the requisite jurisdiction to entertain any matter brought before it. And I made reference to cases which I set out. This now leads us to whether the challenge by the first respondent, whether Dr. Livy Uzoku Ezean, who signed the list of documents to be relied upon in this petition, appearing at pages 141 to 145 of the petition, and the petitioner list of witnesses, appearing on pages 146 to 157 of the petition hearing, is the name of a legal practitioner on the roll by the Chief Registrar of the Supreme Court to enable him practice as a legal practitioner in Nigeria with the right to sign any legal process or document. The implication is that if it is found that the person who signed the petition hearing and the accompanying front-loaded document is not a legal practitioner authorized by the combined effect of sections 2(1) and 24(1) of the Legal Practitioners Act 2004, or that the petition was signed by a legal practitioner whose name is not on the roll of legal practitioners called and admitted to the Nigerian bar as mandatorily and statutorily required as aforesaid, then the entire processes of the petition constituting the petition will herein be moribund and will be liable to be struck out as a matter which goes to affect and rob the court of jurisdiction to entertain the petition. And I made reference to some cases. I must say, with all sense of justice, that what happened in this petition is not a case of someone signing on behalf of a firm or on top of a firm name. It is also not a case of an unknown person signing on top of the name of another person who is unknown. The central focus here is whether the name, quote, Dr. Livy Uzoku Ezean, is a legal practitioner on the roll of lawyers or legal practitioner called to the Nigerian bar and whose name are on the roll or register kept by the Chief Registrar of the Supreme Court. I have noted the processes, and it is glaring that there is a seal or stamp of the Nigerian Bar Association affixed opposite the name, quote, Dr. Livy Uzoku Ezean, and the name was also ticked. The name contained on the MBA stamp is, and I quote, Livinus Ifanichuku Uzoku Ezean, SCN 62, end of quote. And there is the Nigerian Bar Association number A3755467 on the stamp, showing that it is valid up to March 2020. It is also crucial and important to draw attention to paragraphs 5A to N of the petitioner's respondent's counter affidavit in opposition to this application, wherein it is deposed to, and as follows, I quote, paragraph 5, that the deposition contained in paragraph 4H, I, J, K, M, N, O, and P of the affidavit filed in support of the said first respondent applicant's affidavit are contrary to the facts which are known to be true. 6, that I was informed by the petitioners/respondents lead counsel, Dr. Lee Uzoku Ezean, at 37 T.Y. Danjuma Street, Asokoro, Abuja, at about 2 p.m. on the 29th of April 2019, and I verily believe him to be true as follows. A, that he was called to the Nigerian bar in July 1982. B, that Levy, an abbreviation, is an abbreviation of his first name, which is Livinus. C, that his full names, Livinus Ifanichuku Uzoku Ezean, appear on the stamp issued by the Nigerian Bar Association affixed to the petition. The list of petitioners' documents and list of petitioners' witnesses to be relied upon in this petition. D, that he was conferred with the rank of Senior Advocate of Nigeria, SAN, in 1999 by the Legal Practitioners Privileges Committee. E, that by the instrument by which the rank of Senior Advocate of Nigeria was conferred on him, his name was written as Levi I. Uzoku. F, that his name is on the roll of the legal practitioners licensed to practice in Nigeria. G, that there is no other person who was called to the Nigerian bar in 1982 or at any other time that shares the name Livinus Ifanichuku Uzoku with Dr. Levi Uzoku Ezean. H, that the name Dr. Levi Uzoku Ezean endorsed on the petition and other processes filed on behalf of the petitioners/respondents is the same as Levi I. Uzoku, which appears on the Certificate of Conferment of Senior Advocate of Nigeria, SAN, attached hereto as Exhibit AA, as well as Livinus Ifanichuku Uzoku Ezean, which appears on the Nigerian Bar Association stamp and seal, affixed to the list of documents to be relied on in this petition and the list of petitioners' witnesses. I, that Exhibit AA, which was signed by the Chief Justice of Nigeria, is said that the name Levi I. Uzoku is the barrister and solicitor of the Supreme Court of Nigeria. J, that there is nothing wrong in the use of abbreviations in one's name or initials in signing documents, court processes, and or conducting proceedings in any court of law in Nigeria, as was done by him in respect of the list of documents to be relied in the petition and the list of petitioners' witnesses in this case. K, that being an officer of this honorable court, who has appeared in different cases for several years, the fact of his name being on the roll kept by the Chief Registrar of the Supreme Court is not and has never been in doubt. L, that he was Attorney General of Imo State from 1994 to 1996. M, that he has represented the first respondent/applicant in previous election petitions since 1999 without any objection whatsoever to his status as a legal practitioner by the first respondent or any other person whatsoever except in this petition. N, that he is duly licensed to practice law in Nigeria and was admitted to the bar, to the inner bar, in 1999 on the same day with Yunus Ustaz Usman Ezean, the lead counsel to the first respondent/applicants. On the face of this averments by the first respondents, by the petitioners, the first respondents decided to blow a muted trumpet in respect of these fundamental facts in in this petition, in the counter affidavit, showing that the name Dr. Livy Uzoku Ezean is the same as Livy I. Uzoku, conferred with the rank of the Senior Advocate of Nigeria in 1999, along with the first respondent senior counsel, Ustaz Yunus Usman Ezean. The averments also show that Dr. Livy Uzoku Ezean was called to the bar in 1982, and he does not share the name Livinus Ifanichu Uzoku or Dr. Livy Uzoku Ezean with any other person. The law is now tried that when facts are provable by affidavit, and if one of the parties deposed to certain facts, his adversary has a duty to swear to an affidavit to the contrary if he disputes such facts. Whereas in the instant case, such a party fails, neglects to swear to an affidavit to controvert the facts, such facts are to be regarded as duly established and the party deemed to have considered and admitted as true and correct. I made reference to some cases on this principle. In the absence of any affidavit against the fact deposed to in paragraph 5 and 6 of the petitioner's counter affidavit, the first respondent would appear to have thrown in towel and backed down on the allegation that Dr. Livy Uzoku Ezean's name is not on the roll of legal practitioner called to the Nigerian bar. It is therefore not surprising that nothing was said on the issue in the first respondent reply on points of law, which was filed on the 5th of May 2019, concerning this unfounded allegation that Dr. Livy Uzoku Ezean is not a legal practitioner called to the Nigerian bar. In this premise, I am of the view that the petitioner's list of documents to be relied on in this petition and the list of petitioner's witnesses, which were all filed along with the petition hearing on March 18, 2019, appearing at pages 141 to 145 and 146 to 147 of the petition, were all validly, competently and signed by a legal practitioner whose name is on the roll kept by the Chief Registrar of the Supreme Court, and that is Dr. Livy Uzoku Ezean. The next prayer sought on the first respondent application is for an order to strike out ground D and E of the petition because they are said to be incompetent in that they are said to be on pre-election matters. The learned senior counsel had argued that with ground D and E, the learned senior counsel for the petitioners / respondent had argued that because ground D and E affect the second respondent directly, it will not be the business of the first respondent / applicant, an independent body, which should be impartial to hold brief for the second respondent in respect of the said grounds. However, because the challenge by the petitioners, by the first respondent to grounds D and E is a challenge to the jurisdiction of this court to entertain the said ground, it is open to any of the respondent to petition to raise the said issue. The settled position of the law is that consent or acquiescence or failure to raise a jurisdictional point in action will not confer jurisdiction on the court where it has no jurisdiction to entertain any cause or issue. The contention of the applicant in this application is that this court cannot adjudicate on the identified grounds because they are covered by time bar or limitation contained in section 285(9) of the Constitution of the Federal Republic of Nigeria as amended, which provided that every pre-election matter must be filed within 14 days of accrual of the cause of action. The court can, on its own motion, even without any party raising it, raise an issue which directly affects its virus or jurisdiction to adjudicate on any of the issues or grounds contained in this petition. I then refer to the case of Ndu and Wayo, where the Supreme Court, Fakekere Ekun, described the issue of jurisdiction as follows. Jurisdiction is the authority or power of the court to adjudicate over a cause of matter brought before it for resolution and to take cognizance of matters presented in a formal way for its decision. A court of law, being a creation of the Constitution or of a statute, can only exercise the jurisdiction conferred on it by law that created it. See National Bank and another, Shoyoyi, 1977, 5 SC reprint, 110, Mobile Production Nigeria Unlimited, and La Cepa, and others, 2002, 14 SCM, 167, at 179, 2002, 18 NWLR 7981, Obasanjo and Yusuf, 2004, 9 NWLR, part 877144, Achonu and Okwabi, 2017, 14 NWLR, part 1584, page 142 at page 171. Jurisdiction is so fundamental that any proceeding conducted without it is a nullity and liable to be set aside, no matter how well conducted. See Modukolu and Nkendilim, 1962, 2 SCNLR 341, 1962, 2 All Nigeria Law Report, 587 at 594, Scant Counsel Nigeria Limited and UK, 1981, 1 SC6 at 52, Inakoju and Adeleke, 2007, 4 NWLR, part 20, 1025, at page 427, at page 588. It is because of the futility of proceedings conducted without jurisdiction that an issue may be raised at any stage of the proceedings in any manner, even for the first time on appeal, before the apex court. End of quote. I also made reference to some other cases dealing with jurisdiction. Now, the grounds set out in paragraph D, 15D and E of the petitioner's petition are as follows, and I quote them. Paragraph D. The second respondent was at the time of the election not qualified to contest the said election. And paragraph E, the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election. End of quote. The facts pleaded in support of the above grounds of the petition can be found in paragraph 388 to 405 of the petition, and I set them out. The law is now beyond argument that ground D of the petition are set out above on the qualification of the second respondent to contest the election in question is both a pre- and a post-election question or issue, which could be competently taken before the courts mentioned in section 31.5 of the Electoral Act as amended, or the election tribunal or court and this court as a trial court in the presidential election. In the case of PDP and INEC, Supra, cited by the petitioners, Okoro JSC tacitly stated the position when he said, and I quote him, as I mentioned earlier, a person who wishes to challenge the election on the basis that the winner was not qualified to contest the election has umbrage under section 138(1)(a) of the Electoral Act. That is to say, where a person failed to take advantage of section 31, sub 5 and 6 of the Electoral Act Supra in the High Court, he can still approach the election tribunal under section 138(1)(a) thereof. In the later case of Dixon and Silva, a case decided in 2017 and citation of which is set out, Sanusi JSC succinctly put the position thus, and I quote him, as can be seen from the wordings of section 138(1)(a) of the Electoral Act 2010 as amended, the issue of qualification of a candidate to contest an election can be a ground in an election petition to question the election of the declared winner. Such a ground could be fought both at the tribunal as well as the normal or conventional high courts, as both the tribunal and the High Court have jurisdiction, end of quote. These two decisions of the Apex Court, among a litany of others, are sufficient for me to hold and say, without any further ado, that ground D of the petition is a competent and valid ground under the law to vest the requisite jurisdiction on this court to adjudicate over it. Next is ground E in paragraph 15E. Prior to the amendment of the Electoral Act by the Act number 15 of 2015, which came into effect or operation on the 26th of March 2015, there were only 4 grounds provided for under the hitherto section 138(1), on which an election could be questioned in an election petition. The 4 grounds numbered A to D have been retained in the amended Act under the same section 138(1), which, however, has brought the additional ground numbered as E. The new and additional ground on which an election may be questioned in an election petition introduced and provided for under the said 138(1)(e) of the amended Electoral Act is in the following terms, and I quote, E, that the person whose election is questioned has submitted to the Commission affidavit containing false information of a fundamental nature in aid of his qualification for the election, end of quote. It cannot reasonably be argued that the provisions of section 138(1)(e) above are not quite clear, ambiguous, and simple in their words and tenor, and so the only legitimate duty of this court is to assign and ascribe ordinary and literal meaning to them in the determination of the intention of the legislature in enacting them. Okoro JSC, the very recent case of Nweke and FRN, decided this year, 2019, and citation of which he set out, restated this position when he said, and I quote, I must state that the law is well established in the interpretation of the statute, and it is that it should always be given its ordinary meaning. Where the words of the statute are clear and unambiguous, any addition or subtraction will tantamount to introducing illegal backdoor legislation or amendment. See Skybank PLC against Victor Aname, UWU, 2017 LPELR 42595 SC, 2017-18 NWLR, Part 1590-24, Elabanjo and Daudu, 2006 15 Nigeria Wiki Law Report, Part 1001 at page 76, end of quote. See also Obasanjo Yusuf and other cases which I have set out. The provisions of section 138(1)(e) above, put simply and ordinarily, provide that an election conducted under the Electoral Act may be questioned on the ground that the person whose election is questioned has submitted to INEC, the Commission, an affidavit containing false information of a fundamental nature which aided his qualification for the election. Expressly and unequivocally, the purport of the provisions and the legislature is to make the submission of an affidavit containing a false information of a fundamental nature in aid of the qualification of his qualification by a person whose election is questioned, a ground for challenging or questioning the said election of the person. Undoubtedly, the submission of an affidavit to INEC required under section 31(2) of the Electoral Act is an event or act or activity that preceded an election that may be questioned by the ground provided for in the provision, which, however, is intricately and inextricably linked, connected, and tied to the qualification of the person whose election is questioned to contest the election. The legislature, aware of this position, and in its wisdom, has deliberately and expressly made the submission of an affidavit containing false information of a fundamental nature in aid of his qualification a ground on which an election may be questioned, thereby making it a question or issue which can competently and validly be taken before the election tribunal in an election petition. I refer to the case of Okadibo and Obiano, decided in 2015. It has been argued by the learned senior counsel for the first respondent applicant that the ground deals with pre-election matter as defined under Section 285, sub 14 of the 1999 Constitution as amended. The provisions of the said section are as follows, and I quote, Section 285.14. For the purpose of this section, pre-election matters mean any suit by A, an aspirant who complains that any of the provisions of the Electoral Act or any act of the National Assembly regulates the conduct of primaries of political parties and the provisions of the guidelines of the political party for the conduct of primary or party primaries have not been complied with by a political party in respect of the selection or nomination of candidates for an election. Then B, an aspirant challenging the action, decisions, or activities of Independent National Electoral Commission in respect of his participation in an election, or who complains that the provisions of the Electoral Act or any act of the National Assembly regulating election in Nigeria has not been complied with by the Independent National Electoral Commission in respect of the selection or nomination of candidates and participation in an election. And C, a political party challenging the actions, decisions, or activities of Independent National Electoral Commission disqualifying its candidate from participating in an election, or a complaint that provisions of the Electoral Act or any other applicable law has not been complied with by the Independent National Electoral Commission in respect of the nomination of candidates of political parties for an election, timetable for an election, registration of voters, and other activities of the Commission in respect of preparation for an election. End of quote. As can easily be discerned, paragraphs A and B of these provisions talk about an aspirant, in quote, who complains that the provisions of the Electoral Act or any other act of the National Assembly regulating the conduct of party primaries or party guidelines have not been complied with in the selection or nomination of candidates, or who challenges the actions or decisions or activities of INEC in respect of his participation in the election, or the Electoral Act or any other act were not complied with by INEC in the selection or nomination of candidates and his participation in the election, respectively. Section 156 of the Electoral Act as amended, the word defines the word aspirant in Section 156 as follows. Aspirant means a person who aspires or seeks or strives to contest an election to a political office. End of quote. Rose Bible, JSC, in the case of PDP and Silva, consolidated, citation of which is set out, define the word aspirant thus. An aspirant is a person who has a strong desire to achieve a position of importance or to win a competition. An aspirant is a person who contested the primaries. End of quote. See also Ado and Nyako, citation of which is provided. The provisions of paragraph A and B above clearly you would complain by an aspirant in respect of the conduct of political party primaries for selection or nomination of candidates. The provisions therefore have no bearing, no relationship whatsoever with the ground on which an election may be questioned by a candidate or a political party who participated in an election as provided for under Section 138(1)(e) of the Electoral Act. Paragraph C on its part deals with the complaint or challenge by a political party to actions, decisions, or activities of INEC in disqualifying its candidate from participating in an election, or that the provisions of the Electoral Act or other acts were not complied by INEC in respect of the nomination of candidates, timetable for election, registration of voters, or other activities in preparation for an election. This paragraph simply provides for a challenge by a political party to INEC's action, activities, and decisions on disqualification of its candidates, on table for an election, registration of voters, etc., in preparation for an election. Like paragraphs A and B, this paragraph, in my firm view, has nothing to do with the ground on which an election may be questioned as provided for in section 138(1)(e) of the Electoral Act. In the results, I am of the view that the ground provided for in section 138(1)(e) of the Electoral Act as amended, on which an election may be questioned in an election, does not come or fall within the purview or even contemplation of the definition of a pre-election matter under section 285(14) of the 1999 Constitution as amended. The ground does not fall under pre-election matters defined in section 285(14) so as to be affected by the limitation of time prescribed by the provisions of section 285(9) of the Constitution, within which such matters are to be taken, brought, or filed in court. Although the ground would appear to deal with an event or activity that happened before the conduct of an election, like the issue or question of a candidate's qualification to contest an election, which is both pre- and post-election for the purpose of an election, the ground provided for in section 138(1)(e) of the Electoral Act as amended involves an issue or question that can competently be ventilated before the regular courts under section 31(5) and the election and/or the election tribunal or court in an election petition. In consequence whereof, I find no merit in the arguments of the applicant, the first respondent, on prayer 4 of the motion, and it fails and is refused. In respect of prayer 5 of the motion, it are contended that some of the paragraphs of the petition alleging improper accreditation, non-authentication of results, overvoting, inflation and deflation of votes, and wrong entries in Form EC8A ought to be struck out for their being imprecise, nebulous, and vague, having failed to identify the polling units where the alleged infractions took place. The paragraphs involved in this prayer are set out. The first respondent also praised that paragraph E, F, and G, or some of the same paragraph, the petition failed to give particulars of non-compliance or corrupt practices. It also contains that the person alleged to have committed various offenses were not joined, and I listed some of the paragraphs, all the paragraphs. I have calmly and critically examined the impugned paragraphs of the petition as listed out in prayers 5 and 6 of the motion paper, and I am of the view that paragraph 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 159, 160, 161, 162, 163, 190, 195, 198, 199, 200, 260, and 261 are not vague or nebulous. I am of the opinion that since the first respondent has joined issues with the petitioners in the reply to the petition, the first respondent cannot, in fairness, contend that the paragraphs of the petition quoted are vague, nebulous, or imprecise. Otherwise, he wouldn't have joined issues in respect of the same paragraph. Having understood this paragraph well and reacted to them, it cannot be hard to now say that the paragraphs are nebulous, imprecise, and vague. The next prayer to consider are reliefs, the ones in relief 7 and 8 of the motion paper. And they will be taken together because they have to do with the non-joinder persons or organizations accused of intimidation, harassment of voters, and supporters of the petitioners in the election. Some of the persons named in the paragraphs of the petition listed under prayer 7 and 8 were accused of violent acts and bordering on criminality. The main contention of the first respondent here is that this court cannot determine the allegation in the absence of such persons accused of crimes, as that would amount to a breach of their rights and obligation protected under Section 36 of the Constitution of Nigeria. And in argument, rebuttal, the senior counsel for the petitioner said that the army personnel involved in this case were all agents of the first and second respondent. However, no one can run away from the settled position of the law in election dispute that a petitioner who disparages the conduct or character of any person by accusing such persons or individual of crimes or criminal offenses punishable with a fine or imprisonment ought to know that it is mandatory and statutorily required and important to join such person or individual so that they can defend themselves before the court against such allegations. The court would lack the varus or competence to entertain and adjudicate on any accusation, no matter how minute, leveled against any person in a petition where the nature of allegation is criminal. The court would be devoid of jurisdiction to pronounce against or decree against any person who is not before it and who has been accused of the commission of the crime of the criminal conduct. The cases on this principle of law are legion, so I just made reference to a few of them, starting with Egolem and Obasanjo, citation of which is set out, APC and PDP, decided in 2015, also citation set out, where Fabi in particular said that it is basic, that there's no vicarious liability in the realm of criminal law. Anyone who contravenes the law should carry his own cross. The fourth and fifth respondent cannot therefore be found answerable to alleged crimes committed by their unknown soldiers or policemen in an election petition, end of quote. The impugned paragraphs listed under prayer 7 of the petition. The impugned paragraphs of the petition under prayer 7 of the petition are paragraphs 227, 231, 232, 233, 234, 236, 250, 293, 299, 302, 302, 306, 308, 309, 310, 317, 322, 328, 329, 5, 7, 381. While the paragraphs impugned or complained of in prayer 8 on the motion bar are paragraphs 277, 334, 36, 50, 370, 371, 372, and 33. The said paragraphs, after a comment, are all liable to be struck out as they contain serious allegations of crimes and undue interference with the electoral processes against the persons named therein who are not parties in this petition. I have also read paragraphs 277, 213, 226, 236, 326, 334, 336, 349, 350, 352, 385E and F, 368, 369, 370, 371, 372, and 383 of the petition under prayer 8. And I'm equally certain in my mind that they raise and involve serious allegations of crimes, corrupt practices, violence, unlawful interference with electoral processes which have been made against individuals and persons who have not been made parties to this petition. The court cannot make any pronouncement of indictment against the said person or individual without infringing on their fundamental right to fair hearing, as enshrined in Section 36(1) of the Constitution of the Federal Republic of Nigeria, which I set out. Allegations made against persons indicted in these petitions cannot be fairly and impartially be dealt with in the absence of those identified in the paragraphs. Consequently, the said paragraphs are liable to be and are hereby struck out accordingly. In the final result, this application partially succeeds only in terms of prayers 7 and 8 of the motion paper. The paragraphs named therein are hereby struck out once again. The application fails and is refused in respect of prayers 2, 3, 4, 5, and 6 of the motion paper, which are hereby dismissed. The court shall now proceed to deal with the balance of the paragraphs. My learned brother, to my immediate right, to pronounce his decision in respect of this motion.
I agree with the ruling just delivered.
My learned brother, to my immediate left, will also read his own decision in respect of this motion.
I also agree.
Abba. Put them in this area. My learned brother, excuse me. My learned brother to my extreme
I
right.
also agree.
All right. My learned brother to my extreme left will also pronounce his decision in respect of this man.
I agree.
Now go to the next motion that is second respondent. Now go to the next motion. The next motion that is third respondent. The first respondent. That's three. Lastly, for the first respondent, there's this other motion, which he filed on the 24th of April, 2019. And this is the leading ruling in respect of the said application. The application seeks for, 1, an order striking out part 1 of the petitioner's reply to the first respondent's reply to the petition, dated 15th of April 2019, for being in violation of section of the Electoral Act 2010 as amended. And then 2, an order striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 to 24 of part 2 of the petitioner's reply to the first respondent's reply to the petition, dated and filed 15th April 2019, for being in violation of the provisions of the Electoral Act 2010 as amended. And the grounds upon which the prayers are premised are set out. A lone issue, the motion was supported by an affidavit of 7 paragraphs and a written address. Of course, the petitioners filed a counter affidavit of 6 paragraphs, along which is attached a written address. The first respondent also filed a reply on point of law. A lone issue was raised for determination in this application, and it is the contested averments in the petitioner reply in conformity with the express provision of paragraph 16.1 and paragraph 16.1a of the schedule to the Electoral Act 2010 as amended. I went on to consider the submissions of the senior counsel for the parties. On the sole issue. Now, after a consideration of the submissions by the learned senior counsel for the parties, on particularly the provisions of section of paragraph 16.1 of the first schedule to the Act, I went on to decide as follows: that the apex court in the land had in numerous cases treated the scope, the meaning, the function, and the real import of the reply as part of pleadings in civil proceedings and in election matters which are sui generis. While filing a reply in civil proceeding is governed by the applicable rules of court, cease of the cause of matter, filing of a reply in election petition is regulated by statute relating to the said election petition. I made reference to OJ and Babalola. And also the case of Oshodi and Eifumi, among other cases. And I said the Supreme Court had cause to consider paragraph 16.1 of the first schedule to the Electoral Act as amended in the case of APC and PDP, decided in 2015, citation of which is set out, where Fabi JSC said, the last notable issue is whether the Court of Appeal was not correct in his decision affirming the tribunal's striking out of paragraph 13 of the petitioner reply to the second respondent's reply to the petition, when the said paragraph was in fact filed in contravention of the applicable provisions on reply and pleadings. Let me start by observing that paragraph 16(1)(a) of the first schedule to Electoral Act regulates the content of the reply that may be filed by a petitioner in answer to the reply of a respondent to the petition. It provides as follows. 16(1). If a person in his reply to the election petition raised new issues of facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from receipt of the respondent's reply, a petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. I think that I should repeat it, that proceedings and election petitions are sui generis. They are in a class of their own. They are made to fast-track the hearing of petitions. They are, however, not designed to spring surprise on the party, end of quote. More recently, in the case of Silva and INEC, His Lordship, IT Muhammad JSC, now CJM, firmly held, and I quote him, "Your Lordships, the circumstances under which a petitioner may file a reply to the reply filed by a respondent to the petition are clearly provided by the first schedule to the Electoral Act 2010 as amended. It provides as follows, 16(1). If a person in his reply to the petition raises new issues of facts in defense of his case which the petitioner has not dealt with, the petitioner shall be entitled to file a reply in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply to the new issues of fact, so however that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of subparagraph 1 of this paragraph, of paragraph 4 of this schedule. It is clear from the above quoted provisions of the Act that one can easily conclude that a petitioner may only file a reply to the reply of the respondent where any issues of fact are raised by the respondent. Where a respondent raises no issue of fact in his reply, but simply answers the fact in the petition, the petitioner does not have a right of reply to the same, end of quote. In order to determine whether the reply of the petitioners to the first respondent's reply to the petition is competent or in breach of paragraph 16(1) above, there is the need for a reproduction of the preliminary objection by the petitioners, by the petitioner to the reply, preliminary objection by the first respondent to the reply filed by the petitioners. And we went on to set them out. Now, part 1 of the petitioner reply deals with the above the objection with the first respondent tag, A on pages 1 to 4 of the first respondent reply to the petition. On ground A, as to whether they complied with paragraph 4(1)(c) of the first schedule to the Electoral Act 2010 as mandatory requirements of stating scores of the party as announced by the first respondent, and the issue whether the result was pleaded is a matter of perusal of the petition and the evidence at the trial. The petitioner's reply in paragraph 1 is therefore unnecessary. With regard to paragraph 2 of the petitioner reply, dealing with whether there is contradiction in the relief sought, I am of the view that it is a point of law and depends on the examination of the petition itself. Paragraph 2 is therefore unnecessary. Paragraph 3, 4, 5, 6, and 7 of the petitioner reply to the first respondent's reply to the petition are in order because, 1, The first respondents raised the issue as to whether Lion Senior Counsel to the petitioners was called to the Nigerian bar. 2. The first respondent asked the court to strike out the petition and the accompanied list of witnesses and list of documents. 3. The first respondent raised the issue as to whether reliefs D and E, which also constitutes some grounds in the petition as falling under Section 285 14b of the Constitution of the Federal Republic of Nigeria as amended. The first respondent therefore thereby raised new issues of facts in the defense which were not dealt with in the petition. However, paragraphs 8, 9, 10, 11, 12, and 14 of Part 1 of the petitioner reply to the first respondent reply to the petition are contrary to the intendment of paragraph 16(1)(a) and 2 of the first schedule to the Act. The reasons are not far-fetched and are as follows. 1. Paragraph 8 and 9 are efforts at embellishing the paragraphs of the petition already pleaded and explain reasons behind the pleading. Paragraph 10 introduced facts that ought to have been pleaded in accordance with paragraph 4 of the first schedule to the Act. Paragraph 11 introduced principal and agency relationship into their petition in breach of paragraph 14(1) of the first schedule to the Act as amended. And 4, the question as to whether the first respondent is bipartisan or is rallying around the second respondent were already part of the pleading of the petitioner, and same cannot be reintroduced in reply to the first respondent's reply to the petition. The facts contained in paragraph 15 of the reply to the first respondent reply to the petition are for the court to decide. In the result, paragraphs 1, paragraph 2, paragraph 8, paragraph 9, 10, 11, 14, and 15 of Part 1 of the petitioner reply contravene paragraph 16 of the first schedule to the Electoral Act and are liable to be struck out. They are hereby struck out. Part 2 of the petitioner reply to the first respondent reply to the petition has to do with the facts pleaded in paragraph 3, so many paragraph 3 which are set out. All the facts pleaded by the first respondent in their paragraphs 3, 4, and 5 of their reply to the petition are responses to the facts pleaded in paragraph 2, paragraph 3, 4, 5, 6, 7, and 8 and 9 of the petitioner's petition, and no new issues of facts were raised by the first respondent in the said paragraphs to warrant any reply from the petitioners as contained in the said paragraphs. There are new facts and an attempt to add new facts, which is an amendment to the contents of the petition and which are not allowed under paragraph 16(1) of the first schedule. They ought to be, and they are hereby struck out. The first respondent pleaded in paragraph 10 and 11 of his reply to the petition that it denies paragraph 18, 21 of the petition, and denied that contrary to the assertion of the petitioner to wrongly and unlawfully credited the second respondent with invalid votes, and a denial of the table of alleged scores of candidates constructed under paragraph 21, which the petitioners claim to have gotten from the first respondent server. In breach of paragraph 16 of the first schedule to the Electoral Act as amended, the petitioners took on undue umbrage to plead facts in paragraph 5 complaining about wrong crediting of votes to some candidates in the presidential election. The petitioners also pleaded new and additional facts on transmission of results online via the website tagged www.inecnigeria.org. They pleaded further that they visited the website on the 12th of April 2019 at 4:58 p.m. All through paragraph 7, 8, 9, 10, and 11, the petitioner clearly pleaded new facts relating to INEC server, electronic voting, information, data, document, footages, images, and paragraphs, and that the result, photographs, and that the result relied upon by the petitioners are products of electronic transmission of votes cast for the candidates are transmitted electronically by the first respondent's official. Paragraphs 10 and 16 of Part 2 of the petitioner reply to the first respondents are also new facts about what the petitioners described as, and I quote, first respondent presidential results sheet server 1, end of quote. The petitioners also pleaded in paragraph 10 that the second petitioner was reported to DSS and Inspector General of Police on allegation that they hacked into INEC server, and also stated that Mr. Festus Kiyamo Ezien accused the first petitioner of having smuggled the data into the server. Paragraph 11 stated that the petitioners will rely on experts on Microsoft, IBM, and Oracle, among others of the trial. Now, in paragraph 15, 16, and 19 of the first respondent petition, and in answer to paragraph 26, 27, 28, and 29 of the petition, wherein the petitioner pleaded that smart card readers were deployed by INEC in addition to accreditation to transmit results, votes electronically, and that they will rely on the first respondent manual for respondent manual of technology 2019, which the first respondent denied. The petitioners in paragraph 12 to 16 of part 2 of their reply to the first respondent now pleaded additional facts and fresh issues relating to the use of smart card reader, meetings of INEC officials with stakeholders, and press release by one Festus Okoye, Chairman, Information and Voter Education Committee of INEC. The petitioners also pleaded that the Electoral Act did not allow the transmission of election results by electronic means. Paragraphs 8 to 16 of the said part 2 of the petitioner reply are also caught in the web of paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act. Paragraph 16, 19, paragraph 17, 18, 19, 20, 21, 22, 23, 24, 25, and 26 of the petitioner reply to the first respondent also pleaded new facts in addition to the Constitution herein reference, and to the answers and denials of the first respondent, with particular reference to the elections in states which I set out. The first respondent did not raise any issue of fact to engender a reply from the petitioner to file a reply to the first respondent's reply. The petitioners also in paragraphs 107, 108, 109, 110, and 111 of the petition under Grant 2, dealing with non-compliance with the provisions of the Electoral Act 2010, complaint of non-holding of election, cancellation of election results, and stating that because the first respondent admitted the breaches stated, the first respondent ordered supplementary election in 14 states of the Federation, stating the number of polling units affected in paragraph 108, and pleading the results which the petitioners believed were cancelled and that there was voting, that there was overvoting. These complaints pleaded by the petitioners in paragraphs 107, 108, 109, 110, and 111 of the petition are what the first respondent addressed and replied in paragraphs 62(1) to 9 of the first respondent's reply. All that the first respondent said in the said paragraph 62 is that the assertion of the petitioners are misleading and untrue without raising any new issues of fact in the first respondent's defense. The denials contained in the said paragraph 62 of the first respondent reply to the petition cannot attract any reply from the petitioners. The same is also true of paragraph 63, sub 2c of the first respondent's reply. Paragraphs 22 to 26 of the petitioner's reply in part 2 to the first respondent's reply are not permitted and contravene paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act, as there's nothing new or which raises fresh issues of fact in the first respondent's reply in paragraph 64 and 76F in the first respondent's reply to warrant the pleadings in the said paragraphs. The result is that part 2 of the petitioner's reply to the first respondent's reply to the petition, particularly paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 24, 25, and 26 of the reply are liable to be struck out and are hereby struck out for being in flagrant breach of paragraph 16A and B of the first schedule to the Act. In the final result, this motion succeeds as stated above, partially and fails partially. My learned brother to my immediate right will now say his decision in respect of this motion.
I agree.
My learned brother to my immediate left will also say his decision in respect of this motion.
I also agree.
My learned brother to my extreme right will say his decision in respect of the motion.
I agree.
My learned brother to my extreme left will also pronounce his decision in respect of this motion.
I agree.
Gentlemen, I now go to the second respondent's motions. The second respondent has two applications, which we've taken. The first one, all of them were filed on the 14th of May, 2015. I'll begin with the lead ruling in the motion filed on the 14th of May, 2019, by the second respondent, which praised the court for the following reliefs. 1. An order striking out the entire reply by the petitioners filed on the 26th of April together with the witness statement on oath accompanying the reply, list of witnesses to be relied on, and the list of additional documents. Further, or in the alternative to prayer 1 above. 2. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 16 to 20, 21 of part 3 of the petitioner's reply filed on the 26th of April 2019 to the applicant's reply to the petition. And 3, for such further order or orders as this honorable court may deem fit to make.